6 of Schedule 10 of the Constitution. Now, my lords, this is of course the same principle as in continuation with Shivraj Singh Chauhan, which I had read out to your lordships.
Yes.
And there was a question that your lordships had put to me on the day before yesterday, that could someone say that Shivraj Chauhan was only on resignation. That's why I read out those paragraphs that Shivraj Singh Chauhan, your lordships don't just deal with resignation of MLAs. Your lordships categorically in paragraph 78 to 81 talk about disqualification petition under the 10th schedule. And say if disqualification petitions under the 10th schedule are pending, doesn't mean in the meantime they will stop discharging their functions as a member of the House. My next judgment for your lordships' kind consideration, my lords, is Rajendra Rana.
That would be judgment's compilation.
Judgment, no, my lords, now on a point that I'm relying on. Till now, I distinguished on what they were relying on. They were relying on it for two purposes: ex post facto, and that your lordships as a court of first instance can decide. Ex post facto, I explained to your lordships saying that it was qua the speaker, that the events to be seen by him were on the day when they incurred disqualification, not subsequent events or split. And as far as your lordships deciding as a court of first instance was on an issue where it had been there in the High Court for 3 years, then the High Court remanded it back. When it came to the Supreme Court said the assembly election, the term is to expire by the end of the year. So let's decide the matter. That is quite different from this matter in every which way. Now, my lords, kindly have Judgment Compilation Volume 1, bookmark 19, page 834. Context of that exposed for these two. Para 25 on page 855. My lords, before I start, let me tell your lordships the context why I am citing this judgment.
Para 25, PDF 855.
My lord, the Chief Justice.
Yes.
My lords, the reason I am citing this judgment is that in this, at that time, para 3 as a defense was available. At that time. Even when para 3 as a defense was available, the Supreme Court said that the Speaker deholds disqualification, does not embark on an independent inquiry to find out about splits in the political party. He only takes a limited prima facie view of the split within the political party. The reason I'm citing is even when, this is not a question of split, this is not a question of merger, but even where it was a question of split and para 3 was still on the statute book, the court said the Speaker will not embark on an independent inquiry into splits in the political party. Please have para 25 for a minute, my lords, on page 855.
It is only a jurisdictional fact for him to enter to give a finding with respect to disqualification.
Grateful. Grateful. That's all. I couldn't have put it better. That's all. My lords, may I?
Yes.
Yes.
25. In the context of the introduction of sub-article 2 of Article 102 and Article 191 of the Constitution, a proceeding under the 10th schedule of the Constitution is one to decide whether a member has become disqualified to hold his position as a member of the Parliament or of the Assembly on the ground of defection. The 10th schedule cannot be read or construed independent of Article 102 and 191 of the Constitution and the object of those articles. A defection is added as a disqualification, and the 10th schedule contains the provisions as to disqualification on the ground of defection. A proceeding under the 10th schedule gets started before the Speaker only on a complaint being made that certain persons belonging to a political party had incurred disqualification on the ground of defection. To meet the claim so raised, the members of Parliament or Assembly against whom the proceedings are initiated have the right to show that there has been a split in the original political party and then they form 1/3 of the members of the legislature party, or that the party is merged with another political party and hence para 2 is not attracted, On the scheme of Article 102 and 191 of the 10th schedule, the determination of the question of split or merger cannot be divorced from the motion before the Speaker seeking a disqualification of a member or members concerned. It is therefore not possible to accede to the argument that under the 10th schedule to the Constitution, the Speaker has an independent power to decide that there has been a split or merger of a political party as contemplated by para 3 and 4 of the 10th schedule to the Constitution. The power to recognize a separate group in Parliament or Assembly may rest with the Speaker on the basis of the rules of business of the House. But this is different from saying that the power is available to him under the 10th schedule to the Constitution, independent of a claim being determined by him that a member or a number of members had incurred disqualification by defection. To that extent, the decision of the Speaker in the case on hand cannot be considered to be in order in terms of 10th schedule of the Constitution. The Speaker has failed to decide the question. He was called upon to decide by postponing a decision thereon. There is therefore some merit in the contention of the Learned Counsel for BSP that the order of the Speaker may not enjoy the full immunity in terms of para 6 subclause 1 of the 10th schedule to the Constitution, and that even if it did, the power of judicial review recognized by the court in Kehoto Holohon is sufficient to warrant interference with the order in question. In a sense, this aspect may not be of great importance in this case, since going by the stand adopted on behalf of 37 MLAs, the Speaker was justified in keeping the petition seeking disqualification of 13 MLAs pending, even while he proceeded to accept a case of split in BSP. The question really is whether the Speaker was justified in doing so. As we have indicated above, the whole proceeding under the 10th schedule to the Constitution is initiated or gets initiated as a part of disqualification of a member of the House. That disqualification is by way of defection. The rules prescribed by various legislatures, including the UP legislature, contemplate the making of an application to the Speaker when there is a complaint that some member or members have voluntarily given up his membership or their membership in the party. It is only then that in terms of 10th schedule, the Speaker is called upon to decide the question of disqualification raised before him in the context of para 6 of the 10th schedule. Independent of a claim that someone has to be disqualified, the scheme of the 10th schedule or the rules made thereunder do not contemplate the Speaker embarking upon an independent inquiry as to whether there has been a split in the political party or there has been a merger. Therefore, in the context of 102 and 191, the scheme of the 10th schedule to the Constitution, we have no hesitation in holding that the Speaker acts under the 10th schedule only on a claim of disqualification being made before him in terms of para 2 of the 10th schedule. And now, my lords, kindly read this with para 37, and then I'll come back to one more para I need to show. Please first have para 37. PDF page 862, my lords. That's the last of it. My lords have para 37.
Yes.
Thus, in the above decision, it has been clarified that it is not enough that a claim is made on a split in the original party, in addition to showing that 1/3 of the members of the legislature party have become out of the party, but it is necessary to prove it at least prima facie. They say prima facie, yes, but all the time emphasizing on this whole thing that the Speaker will embark upon a full-fledged inquiry into the political party, the talukas, the districts, and decide on a split in a political party is without jurisdiction. Quite apart from the fact that you're seeking to draw an artificial distinction which does not exist. And I'll come to that judgment. That para of Sadiq Ali, I'll show to you, lordships, which is important for this. Now, my lords, kindly have, only for that other issue of ex post facto, we'll just sum it up on para 34 of the same judgment. I just need to show that.
Here comes the test. The test is here.
Yes. 860. 860. Para 34. My lords have that?
Yes.
As we see it, the act of disqualification occurs on a member voluntarily giving up his membership of a political party or at the point of defiance of the whip issued to him. Therefore, the act that constitutes disqualification in terms of para 2 of the 10th schedule is the act of giving up or defiance of the whip. The fact that a decision in that regard may be taken in the case of voluntarily giving up by the speaker at a subsequent point of time cannot and does not postpone the incurring of disqualification by the act of the legislature. Similarly, the fact that the party could condone the defiance of a whip within 15 days or that the speaker takes decision only thereafter in those cases cannot also pitch the time of disqualification as anything other than the point at which the whip is defied. Therefore, in the background of the objects sought to be achieved by the 52nd Amendment of the Constitution and on a true understanding of para 2 of the 10th schedule with reference to other paragraphs of the 10th schedule, the position that emerges is that speaker has to decide the question of disqualification with reference to the date on which the member voluntarily gives up his membership or defies the whip. It is really a decision ex post facto. It is in this connection that the observation is made that subsequent facts or split, seeking a defense or split under the 10th schedule will not be looked at. You will see on the day you went to meet the governor in the facts of this case, some of the MLAs with the opposition party and asked the Samajwadi party to form the government was an act which was squarely hit by 21A. And that is why, my lords, I had respectfully submitted and read out instances of Ravi Nayak of this judgment. They were overt acts under 21A. Yadurappa's judgment clearly says merely because within the party I say I do not support a particular coalition of a government is not a 21A case at all in the matter. In any case, my lords, who will decide it? Whether it's a 21A case or a 21P case, it still has to be the speaker under para 6 who's the sole and exclusive constitutional authority to decide it. So A, I'm not a 21A case. B, Yadurappa is held merely because you show support to a government is not a 21A case. And thirdly, my lords, in facts of these cases, the facts which have to be seen are the facts on that date. The ex post facto is in that context. Ex post facto doesn't mean that since your disqualification will be decided on the date you incurred it, all your acts as members of parliament or members of the legislative assembly get annulled in the process. And that is the deduction sought to be drawn now from the words ex post facto in Rana's judgment. Now, my lords, kindly have, just last two judgments and I'm done. Kindly have Rameshwar Prasad versus Union of India. Same volume, bookmark 16, para 165. Relevant para 165 is at page 521.
What's the, sorry, page?
PDF page.
Page 521.
PDF page 521.
Same compilation.
Same volume,
PDF is 390.
521. My lords have para 165. May I, my lords?
Yes.
If a political party with the support of other political party or other MLAs takes a claim to form a government and satisfies the governor about its majority to form a stable government, the governor cannot refuse formation of the government and override the majority claim because his subjective assessment that the majority was cobbled by illegal and unethical means. No such power has been vested with the governor. Such a power would be against the democratic principles of majority rule. Governor is not an autocratic political ombudsman. If such power is vested in the governor or the president, the consequences can be horrendous. The ground of maladministration by a state government enjoying majority is not available for invoking power of 356. Remedy for corruption or similar ills or evil lies elsewhere and not in Article 356. In the same vein, it has also to be held that power under 10 schedule for defection lies with the Speaker of the House and not with the governor. The power exercised by the Speaker under the 10th schedule is of judicial nature. Dealing with question whether power of disqualification of members of the House vests exclusively with the House to the exclusion of the judiciary, which in Britain was based on certain practices of the legislature, as far as concerned, it was said in Quixote. It is therefore inappropriate to claim that determinative jurisdiction of the Speaker or the chairman of the 10th schedule is not a judicial power, is within the non-justiciable legislative area. So the reason I'm citing this judgment, my lords, is for the fact that for A, of course, we say that the chief minister lost his majority. the coalition government could not survive. We within the party were the overwhelming majority. And even if their argument was to be accepted, which I'm not conceding, that, oh, you cobbled it up together in an illegal mean, etc., which it is not. It was a perfectly legitimate government which was sworn in. The governor is not to sit on these matters and make his assessments if a probable, plausible coalition or partnership comes before it and says, because ultimately at the end of the day, someone has to head a government, my lords. My lord, the Chief Justice posed a question to me yesterday. After the sitting Chief Minister resigns, someone has to be sworn in. Now, if a set of people come and show that they have a sizable or an overwhelming majority, he says, go and test it on the floor of the House. And what time does he give? 2 days to do it. And your lordships have normally said those cases where you're given a month, 2 months, and that is scope for horse trading, etc. He immediately calls for a floor test in exercise of his constitutional duties and obligations and say, prove your majority. If you are the new government which is taking its claim within the same political party, now in coalition with another political party who is a pre-poll ally, what is wrong with that decision of the governor within 2 days?